All right. Morning, everyone. My name is Jennifer Miller. I'm a partner at Bennett Jones, and I have a practice focus in occupational health and safety. My friend Hugh McPhail will be speaking after me. I'm going to be focusing on where we're at from a legal perspective in Canada, and we'll also be addressing the current state of occupational health and safety law as it applies in this area, particularly in Alberta. If we start with the where we're at right now, as you're well aware, 2000 to 2018 is showing us the greatest change in the use of cannabis we've seen in our lifetimes. And from a legal point of view, the issues are material. The number of authorizations for medical marijuana have exploded. As you can see on my slide on the screen, there were between 2014 and 2016, there was more than a 1,000% increase in authorizations in Canada. And of course, those authorizations have continued to increase, and I believe that that will continue to be the case even after cannabis has been legalized in Canada. You can also see on the screen the number of companies that are authorized in Canada. We're up to 90 as of February of 2018. When we think about how this area of the law in Canada has changed, I know that a lot of commentary has focused on the Liberal government and some of the thinking that they've had on the topic, but as many of you might know who study this area, the authorization, legalization for the use of marijuana for medical purposes actually started in the year 2000, thanks to a Court of Appeal decision that I have on the screen. We've had a huge change since that decision between 2000 and 2016, when the access to cannabis for medical purposes regulations came into effect. Those have been amended slightly, as many of you will know, but the current state of the law for those authorizations is now on the screen behind me. We expect that these regulations will continue to be amended as this area develops, but right now you can see that the limits are pretty clear in law. What I find interesting and what I want to talk about with this area is the concept of the medical authorizations that are being issued. These regulations speak to what this document must contain when the authorization is issued. And you can see again on the screen that the medical document must specify the daily quantity, the period of use, that the period of use must not exceed 1 year, and it begins on the date that the authorization has been issued. On a lighter note, this is not what a medical authorization looks like in Canada. This is in fact a card that I bought at the Artworks in Edmonton for the low price of $5.50. It's here on display for all of you to see. I've sent a few of these to my clients. It's an enjoyable little activity if you'd like one. Again, with the concept of these authorizations, this is particularly important for workplace use. So this, if you haven't looked at these before, I would encourage that you do look at them. The College of Physicians and Surgeons of Alberta have published, and these are on their website, so they're readily available, standards of practice for the authorizations in Alberta. And again, for workplaces, these authorizations are quite critical because one of the criteria in Alberta, according to the College of Physicians and Surgeons, is that a physician who chooses to treat patients with cannabis must attempt and find conventional therapies ineffective in treating the patient's medical condition or symptoms. This is one of the threshold pieces before an authorization can be issued in Alberta. Further, according to this standard of practice, and this is a verbatim capture from their website as of yesterday's date, is that the physician completing the authorization must also evaluate the patient regularly, at a minimum see the patient every 3 months following stabilization, which is defined within the standard of practice, and then provide ongoing care for the patient to monitor for, among other things, addictions using standard addictions tools. There's also an advice piece that is tied to the standard of practice, which is also very important to review, and that goes to the informed consent that goes behind the actual authorization. And the criteria for the informed consent are actually laid out in the advice to the profession. And again, like the last slide that I focused on, this is a verbatim partial summary of what was on this advice to the profession on the website as of yesterday's date. You can see that one of the pieces of advice that the college in Alberta is mandating must go behind an authorization is that impairment in cognitive function that may impact fitness to engage in activities and or responsibilities must be addressed, and that patients should be advised to neither drive nor operate equipment while under the influence of cannabis. Now, as you can imagine, the critical part of that sentence is under the influence, which is the difficult part of this equation. But it goes on, and some of the other points, and this is not an exclusive list of what is on this document, is that impacts on safety-sensitive occupations potentially necessitating work restrictions or limitations must be discussed. You can see here that physicians must ask about job tasks and counsel patients, and that there are individuals who may serve in positions that are incompatible with usage. The other part of this that I found quite compelling, and I think it's important for the discussion, is that there may be impacts on insurance that the patient should be advised to look into as well. So this isn't legal advice of any way. This is just a reminder of what is already in place through the College of Physicians and Surgeons of Alberta. I think the important piece of this is that when a patient receives an authorization and they are actually employed in an occupation, they need to understand what potential impacts they might be engaged in with their occupation so that they can be prepared. And now the roller coaster speeds up. As you all know from this very conference, we're on the eve of legalization. I don't know if this has been discussed in earlier sessions or whether this is going to be discussed after lunch, but the status right now of the Cannabis Act is that it was first introduced in the House and Commons on April 13 of 2017. It received first reading in the Senate in November, and it's currently undergoing its second reading right now. So as you know, likely from watching the press, I think it's unlikely that we're going to be looking at legalization in full before July, but I think that remains to be seen. You may also know that thanks to Bill C-46, there have been other collateral changes to the Criminal Code of Canada that will help monitor for at least public usage. There's more law to come, obviously. As you know, and this is important to emphasize because there was an arrest in Edmonton either yesterday or the day before, that possessing and selling marijuana for non-medical purposes is still illegal everywhere in Canada. So let's wait and see. So I believe that one of the other speakers at this conference is actually from the very secretariat that I'm mentioning on this screen. I have received prior approval from members of the Government of Alberta to include this in a slide at a prior conference. There is a cannabis secretariat who's been put into play to help study and perhaps influence how federal legalization of cannabis can be properly regulated in our province. There's a website that I'm highlighting on the screen if you'd like to provide input to them. Because I'm an occupational health and safety lawyer, my real interest in both the medical authorization of cannabis and the legalization of cannabis is about this piece of legislation, and it's the Alberta Occupational Health and Safety Act. I know this is an employers-based conference today, but Right now, we are working with a fairly old version of the Occupational Health and Safety Act that will be changing on the 1st of June of this year. At this moment, the concept of a worker's fitness for work is managed only by a handful of sections in the Act, regulation, and the code. There is an employer's general duty to ensure a safe workplace, and there is a worker's general duty to ensure that they are working safely both for themselves and for the other workers around them. There is also a part of the Occupational Health and Safety Code that addresses the concept of hazards and hazard management in the workplace, where an employer has a duty to eliminate hazards in the workplace, and if elimination is not reasonably practicable, the employer has an absolute duty to control those hazards through a variety of measures. Those sections right now are the only ones that we really have to guide workers, supervisors, and employers in the province of Alberta with respect to fitness for work, whether that fitness is about the use of a prescribed drug that has a drug identification number, or a substance such as alcohol, or a medical authorization for cannabis, or the future legalization of cannabis. On the 1st of June, the Occupational Health and Safety Act will change, but what we know about Bill 30, which amended the Act, is that there's really not a lot that's new in that Act that addresses fitness for work. So my hope as an occupational health and safety lawyer is that in future amendments to the regulations to the Occupational Health and Safety Act and the adopted code under the Act, that we will see some form of fitness for work regulation that will help every employer and every worker in the province of Alberta understand how we can all work together in a safe fashion while still allowing workers to receive authorizations, prescriptions for drugs that have a drug identification number, and to otherwise engage in social activities. I think from an employer's perspective, for one moment, I just want to highlight one thing for you here, because I think that this goes to the threshold of the work that has to go into policy and practice development, is that if any of you have ever been involved in an occupational health and safety incident, you will know how seriously this regulator takes worksite safety. And when you get into a prosecution under this act, which by the way is a quasi-criminal offense, if you wind up in a trial of one of these matters, the employer will ultimately have to prove the concept of due diligence, most cases. And when you need to prove due diligence, it's usually one of two defenses, and I have to put both of them up on the screen to be accurate, but the top one is the one that we're usually engaged in. And you can see there that the threshold about implementing a safe work site is that an employer has to exercise reasonable care, which is all reasonable care, or the level of judgment, care, prudence, determination, and activity that a person would reasonably be expected to do under the particular circumstances to avoid the particular event. This threshold applies to ensuring that workers at work sites are fit to work, whether it's due to hours of work or their cognitive ability to be fit for work due to the use of any substance. And I think that this is something, if there's anyone from the government here, that I would encourage them to do, is that when we're looking at future amendments to the regulations and the adopted code, that we give workers and employers some better guidance on how this could be implemented to ensure safe work sites in our province. There is some guiding legislation in the province of Alberta in the occupational health and safety regulations there that would be a terrific starting point with some modification, possibly with some inclusion from the current COA model that is being used by the Construction Owners Association of Alberta. I'm going to stop here. I know it's very hard to hear in this room. I hope that you've been able to hear some of this. I'm going to turn the mic over to Hugh McPhail, QC, and he's going to be addressing the human rights components of this area of the law. Thank you very much.
Thank you very much, Jennifer. Good morning, everyone. I trust that some of you can hear me and that some of you are listening, but it's hard to tell when you're up here. My name is Hugh McPhail. I'm a partner with the firm McLennan Ross. We have offices in Edmonton, Calgary, and Yellowknife. I'm in the Edmonton office, and I've advised employers for about 40 years. We were asked to address the cannabis intersection with the workplace, and Jen has given you the lead-in, which is identifying that fundamental occupational health and safety responsibility that employers have, and that should be evident to all of us, and that concern about health and safety is, of course, a concern of all workers. In fact, many of the times that my clients have to deal with concerns, it's because coworkers came forward with those concerns, that they were bothered that they were not working in a safe environment. Needless to say, there's collisions of various interests that are critical in this area, and it's very, very important to understand them. As Jennifer has identified, an absolutely fundamental obligation, a quasi-criminal responsibility resting on the employer under legislation that is enforced with some vehemence, is to make every effort to ensure that the workplace is safe. That goes up against the legal obligation to accommodate disabilities, to the point of undue hardship under human rights legislation, and I'll expand on that a little bit. And those are important terms of art. It's only disabilities that are protected, and the obligation to accommodate is only to the point of undue hardship. And there's some other aspects of human rights law that play into this that it's very important that employers understand and really employees to understand as well. And the third clash here, of course, is privacy. To what extent does an employer have a right to know about the employee's off-duty activities? The first Prime Minister, Trudeau, was the one that said that the government has no place in the bedrooms of the nation. But obviously, the law of privacy has expanded in recent years as well. In fact, not many years ago, you could say that there was no legal right to privacy. Now it's recognized that there is, in law, a legal right to privacy that has certain limits and restrictions, but you're even able to sue somebody for intrusion on your seclusion. There is such a thing as a right of privacy. But we're talking then about three conflicting rights and interests, and what I will try to do is try to explain how those have been rationalized in the law and by the courts and other tribunals that decide these things. So, first question is an obvious one. Can an employer refuse to hire someone who's legally using cannabis? And generally, an employer can choose to hire whoever he wants to hire. An employer can decide that he's not going to hire anybody with a beard, for example, or that he's not going to hire redheads. Somebody's shaking their head down here. Or redheads, or somebody can decide, like I suspect one of the fellows I work with, He seems to hire articling students on the basis of whether they can play a musical instrument so they can be part of the band at the Christmas party. There's limited legal restriction on who you can hire. The Alberta Human Rights Act is the one that applies to most employers in Alberta. Of course, there's some people governed by federal law that are working in Alberta, and it's similar. The main one we have to be concerned about is, of course, the Alberta Human Rights Act. It protects discrimination on the basis of specified grounds, and only those specified grounds. So, kids these days are quick to adopt these phrases. Kids don't have to be very old nowadays to pop up and say, hey, I've been being discriminated against. That's the new way of saying I've been picked on or I'm being picked on. And so discrimination is nothing other than treating A differently from B. That's discrimination. One of them is being discriminated against. But human rights legislation doesn't protect against all discrimination, only discrimination on enumerated grounds like sex, age, national origin, so forth. And one of those categories, and the relevant one for our discussion today, is disability. You cannot discriminate against somebody because of a physical or mental disability. And a fundamental disability recognized in law is, of course, substance dependency. Not just substance abuse, but substance dependency. So we will often have situations where there's a debate about whether the individual is only a casual user, or whether they are an abuser, or whether they are substance dependent. And that's one area where experts get involved. Casual use is not dependency. Dependency is the only thing that's protected by human rights legislation as a disability. Mind you, if you are suffering from a condition, which is itself a disability, and it is proven that you require medication for the treatment of that condition, then human rights law would also protect your right to have that medication if that medication is required for that disabling condition that you've got. And that's often a point of great controversy. To receive a medical authorization is not necessarily a doctor's conclusion that this is a medicine that you need to treat something. Not necessarily a conclusion about that at all. That's a different legal question. So the starting point, and it's only the starting point, and it's only step one, that says you're not supposed to discriminate on the basis of disability. And then it's important in an understanding of human rights law to know that everybody's excused from discrimination if there's a bona fide occupational requirement. So, what is a bona fide occupational requirement? Let me give you an example. If you were hiring a hockey referee and you said, one of our requirements for this occupation is that you have good eyesight or that you are not blind, to be more blatant about it, one would hope that you're not going to be hired as a hockey referee, although many of them are accused of being blind, of course. So that's an example of a bona fide occupational requirement. And that works similarly when we're talking about cannabis use and its clash with the employer's interests. Can an employer say, we will not hire anybody who is a user of cannabis? Does a positive test, in other words, justify a refusal to hire someone? And in some cases it will, and in some cases it won't. And it's very difficult to be definitive one way or the other. It's all, you're probably sick and tired. If you've been around lawyers at all, you're sick and tired of them saying, it depends. But it does. It depends on all the surrounding circumstances. But the fact is that there are some jobs where you could legitimately say, I'm sorry, I will not hire pot smokers. And that would be a bona fide occupational requirement, and that would be a defense to any human rights complaint, and it would be the only complaint that you could file if someone didn't hire you. However, those circumstances are generally probably limited to circumstances where it's a safety-sensitive job. A common question we receive all the time, of course, is what the hell is a safety-sensitive job? But that'll be a phrase that you will hear bandied about, and it's going to be bandied about more and more as we try to sort out the problems that loom here. There's a lot of problems going ahead here, but I'll just read you one definition if anybody can hear me. This, I think, is quite a carefully prepared one. It's a position with a key or direct role in an operation where, if actions or decisions are not carried out properly, it could result in a serious incident affecting the health or safety of employees, customers, others, or the environment, or an inappropriate response or failure to respond to an emergency or operational situation. So you can see that safety-sensitive jobs could include operating equipment. It could include some people that sit at a desk that make critical decisions that require them to be mentally sharp. And broadly, one can say that there's some recognition that if you're going to be working in a safety-sensitive position, you should ordinarily not be using cannabis. But it's not black and white, and it's not as simple as that. Okay? Let me go on a little bit and talk about how we get there. So, sorry, I can follow up on this and just summarize this for a moment. Can you refuse to hire somebody? Perhaps yes. What can they do if you don't hire them? The only real remedy somebody's got if you refuse to hire them is a human rights complaint. If you're going to succeed in your human rights complaint, you have to prove a disability. The answer to a disability is a bona fide occupational requirement, and then you're into that analysis, okay? Sorry, I don't think this is thrilling information for you guys to get in this environment, but testing rights for the employer. So assuming, first of all, you may be subject to a pre-employment test, but assume you get hired, what other testing rights are there? Pre-employment is probably something that can occur if there's a safety-sensitive job. It's difficult to justify it otherwise, but many employers do it for all safety-sensitive jobs. It is generally accepted in Alberta, and as common as can be, that testing is allowed after a significant incident. If your actions might have had something to do with the incident occurring, if it's a reasonable line of inquiry that your impairment was a factor in the incident, then you can be subjected to post-incident testing, and that's generally accepted out there on the work sites. It started with the big oil sands operators, but it spread more broadly than that. Post-incident testing is very common and very rarely challenged. And when it's been challenged, it's been unsuccessfully challenged. And some employers got real stupid about it. And if somebody was sitting in a car that was rear-ended, but their car was stopped as it should have been, some employers got crazy and were testing the driver of that car, who was only sitting in his car and got rear-ended, and that's stupid and isn't legally authorized. But if your actions and possible impairment are a reasonable line of inquiry, then usually employers can test you. I was involved in the rolling out of the first site access testing in Alberta, which was at Albion Sands, oil sands operation, and it's spread beyond that. It's at many, many big facilities, and it's done by other employers as well. And generally that can proceed without challenge. There are still a substantial number of people that are failing those post-incident tests in the construction industry, where it's most commonly performed. Still 3-4% fail those post-incident tests, even though they've got plenty of warning, several days to get there, and they're failing not just marijuana, which stays in the system for a long time, but failing on all kinds of other things that are only in your system for a very, very short time. It's more controversial in other provinces. There's cases that attack it, but in Alberta, we've seen it, and it's not only accepted broadly by employees, but trade unions generally have accepted it. Reasonable grounds testing is something where the employer has reason to suspect that you're impaired on the site, and that can come about from observation, slurred speech, that sort of thing. It can come about from smelling cannabis in your vicinity. It can come about by finding drug paraphernalia in your vehicle, and it can come about by reports from coworkers. Employers are usually pretty sophisticated now in having checklists and evaluation systems that determine whether there's reasonable grounds to demand a test, but they're commonly performed in Alberta. You've probably read in the paper the last day or so that Suncor's random testing program has been delayed again. I haven't had direct involvement in that. I was representing some interveners in the Court of Appeal last time up, second last time there. But I have seen the body of evidence there, and in my personal opinion, it's only a matter of time before there's going to be random testing. And the people that I talk to say, and I'm talking about union people, I'm talking about employees and employers, they say, look, at the site access test is useless. People know that game, and the only thing that will have any effect on reducing usage, if that's the employer's objective or the owner's objective, is through some type of random testing. But I won't go into detail on the Suncor case, except to say that if you ever looked at all the evidence that Suncor has, the amount of positive tests they've had post-incident, and the continuing failure rate on other types of testing, and the information they have about paraphernalia they find on site and bottles on site and all those sorts of things, it's really an overwhelming body of evidence. So they're held up probably for another year or two, but I'm confident it will proceed. Somebody's going to proceed with it. So just a note here that we were told that today we're really talking to employers. So I will, that's an explanation for this approach with you guys, is that the terms of an employer's policy are really very, very important. It's important for clarity, so the employees understand their rights and obligations. It's very, very important to ensure that the employer's interests are properly protected as well. I was at a conference in the fall, and a very senior person, one of the architects of the federal legalization process, expressed the view that, well, gee, of course, you can't be a user of cannabis and be in a safety-sensitive job. That's obvious. Sorry, it's not. it's not completely obvious. It's an expert opinion debate. And there's a rather stunning City of Calgary case where an equipment operator provided the supervisor with details about his medical authorization to use marijuana. They let him operate his equipment for a year, and then somebody higher up found out about it and said, "Good God, what the hell have we done here?" and removed him immediately from his safety-sensitive activities. But there was a clash of medical evidence in that case, and the arbitrator was not convinced that he was unable to perform a safety-sensitive job, considering his dosage, the concentration, when he took it, and all of that sort of stuff. So I talked a little bit about the hiring process and the human rights protection there. Let me just expand on that a little bit. It protects against refusals to hire, discrimination during employment and terminations, but it's got to be because of those prohibited grounds. And as I said, disability is the key one here. There was a very, very important decision out of Alberta, went to Supreme Court of Canada, just decided about a year ago, I think. And this plays back into this point about the importance of the policy. In that particular case, this guy was a user, he was dependent, but there was an employer policy that clearly said, you are obliged to disclose to us that you are using cannabis if you are. What happened was he was involved in a significant incident. It was actually cocaine that he was using, I think. That's the first time the employer found out about his use. The employer, Elk Valley Coal, fired him for breach of the policy for not disclosing his use. The Human Rights Commission of Alberta dismissed the complaint. They said, you were not fired because of your disability. You were fired because you failed to disclose that you were using it, and therefore you prevented the employer from managing it. Okay? A very significant case. Supreme Court of Canada. So where is this all going for employers and employees in Alberta with legalization? It is going to be a messy situation. It's going to get very complicated. And here's a few points that bear on that. You'll no longer be able to refuse to hire a user just because he's involved in illegal activities. Up till now, in fact, today, without a medical authorization, if somebody reveals to you that they're a user of cannabis, marijuana, they're not dependent on it, you can just say, I'm sorry, I don't like people that are breaking the law working for me. And that's not unreasonable. It might not be just cause in all cases, but the illegality is makes it easier for employers to manage. With legality, then you just lose that element of decision making. I don't know what you guys think, but judging by the crowd here, I think the second point is probably valid. There's a lot of interest in use. There'll be a lot more casual users. It's going to be much more common, so we're going to see it more often, and employers are going to be faced with more and more cases of individuals using and also telling them about it. There's one expert, and I'm not a medical expert, there's one expert who's a physician in Edmonton, Dr. Brendan Adams, who has written a very comprehensive paper reviewing all of the literature, all of the studies that have been done on this topic, and he concludes that chronic use, which is typical in medical authorization scenarios, is fundamentally inconsistent with being in a safety-sensitive role. Not everyone agrees with that, so it's fair to warn employers that there could be a difference of opinion about that. And that's chronic use. How about casual use? How about the employee that comes forward and says, I was at a party and I smoked a joint on Saturday night. What do you do about that? Recognizing your occupational health and safety responsibilities and all of that. So what do? People have got to get educated, and you've got to have some way to provide an answer on how you move forward with those cases. So I could have started it with this. It probably wouldn't have been a bad idea. Some myths. One common myth is that, of course, all of you have seen this. I've certainly seen it myself when I was in a vehicle heading down to Nelson with somebody who was smoking a joint at the time. I was thinking, what am I doing here, and how hell can I get out of here, because this guy's whacked. But he believed that nothing unsafe about that. It's the last point, really, that I'm sorry, these were reordered in the version that I have, but I was referring to the last one here, that I'm a better driver. There's still some people think that you're a better driver, and I'm sure people have any experience with this would understand that doesn't make any sense. But the other myths that some employees will have, and that employers therefore should try to ensure that people understand, is that it is a myth that casual use is protected by human rights legislation. The top one as well, medical authorization is a free pass to allow use even in safety-sensitive positions. And I've run into this half a dozen times already, where workers come in and they've got a highly safety-sensitive job, and they say at the hiring interview, well, here's my medical authorization, by the way, and off we go, thinking that they can just come onto the job site. Sorry, it's not that simple. The more fundamental obligation, the absolutely most fundamental, is safety. But there's another myth, and I should have ordered these differently. But the second one is an important one too, and that's an employer misconception. Some employers still think that a positive test justifies termination, but also some employees think that. And they think that in the world out there, that if there's a positive test, that's going to automatically just lead to a termination of their employment. It's not that simple. That's usually not what happens. A positive test is an identification that they're a riskier person to have working, and it requires an evaluation by an expert on whether they are therefore safe to work, whether they required to undergo a rehabilitation program, whether this was a one-off isolated thing that can just be ignored, and so forth. So employers should be very careful to jump to any conclusions with a positive test, because it could mean a variety of different things. It requires further exploration. So I've got about 2 minutes to go. I'd like to just tell you about a classic problem that one of my clients has that will illustrate what we face going ahead here, because the problem is this: the federal government is going to legalize it. They passed laws as well to make sure that our highways are safe in spite of that, where they've given the police certain powers, they've set thresholds for the amount that is allowed in blood samples and so forth, but they have done nothing about workplace safety, really. And there's a void there, as Jennifer has already mentioned, that the provincial government should make an effort to fill in some way, because there is a problem here. And it's not as simple as this federal government person who steered this process perceived at the beginning of things. But just to give you an idea of the sorts of issues that you're going to face as employers, just think of this. They get a report. The employee saw a neurologist, told the neurologist that he was using pot very heavily. But the employee then went to a cannabis clinic and got authorization, received his oil that was high in CBD, very low in THC, only about 1%, from a licensed producer, so that's all legal and so forth. But the neurologist says the underlying condition does not impact safety. It's not an issue, the condition itself that he's being treated for. He should be, but also, and this is interesting and not unusual, he should be able to manage the condition alone without cannabis. In other words, cannabis is not required to treat his condition. But the authorizing doctor has opined that his ability to work safely is not a problem. There's no safety risk of him working as long as he is only using the oil that is authorized, that is very low in THC. But the other person is saying, but I don't know whether or not he's still smoking pot heavily like he said he was before all of this. But if he is only taking it at bedtime, 8 to 12 hours before he starts work, the likelihood of him being impaired while at work is low. But is he smoking in addition to that? Is there a way to test to know whether he's smoking in addition to that? Maybe yes, maybe no. So the employer basically had an answer, this agglomeration of evidence that doesn't give them an answer, doesn't give them much of a path forward except to make more inquiries. And some of these cases are going to be, as a result of this sort of information, hellishly difficult to manage. So there is a collision of interests here, and there are going to be collisions that are concerning. And this is going to be a difficult period for employers to manage.
Okay, thank you. Let's hear a round of applause for our panelists. So I just want to let everyone know that the